Senator Palacios, Senator Pangilinan, Senator Respicio, Senator Rodriguez, Senator Silva Tyron, Speaker Wampen,
Yeah.
Senator Yamashita. Madam Speaker, there are only 5 in attendance.
Thank you very much.
The Guam Legislature is back in session. Madam Clerk, would you please call roll?
Senator Tom Ada. Senator Tom Ada. Senator Tony Ada. Senator Blas. Vice Speaker Cruz. Senator Duenas. Senator Guthertz. Senator Mabini. Senator Munia Barnes. Senator Palacios. Senator Pangilinan. Senator Respicio. Senator Rodriguez. Senator Silva Tyron. Speaker Wampet. Senator Yamashita. Mr. Speaker, there is a quorum.
Thank you very much. Madam Speaker, I believe you're up next on the agenda with 509.
Thank you very much, Mr. Speaker. I'd like to make a motion to place Bill 509 as substituted by the Committee on Education and Public Libraries on the third reading file, and it's relative to the Student Financial Assistance Programs.
Hearing no objections, so ordered.
Thank you again, Mr. Speaker. Mr. Speaker, what I'd like to do is just give a background of the Student Financial Assistance Programs, known as SFAP. And what I'd like to do here then also to make it, easier for our colleagues will be just to go through, give you a background and go through the articles. The Student Financial Assistance Program is a set of student financial assistance programs available to Guam residents who are U.S. citizens or permanent resident aliens. The programs are codified in 17 GCA Chapter 15. Programs include the Government of Guam student loans, merit awards, professional and technical awards known as the ProTech Awards, the John F. Kwan Memorial Scholarship, which is for Marine and Ocean, nursing loans, the Pedro Doc Sanchez Scholarship, nursing training, Hero Scholarship Program, and the Yamashita Teacher Corps. The main goal of the bill is to enable the University of Guam more control on how these programs are administered and awarded. UOG is better able to award these funds to students as they can best identify the type of students that need these awards the most and the academic majors that are most needed on Guam. The bill maintains the core programs of SFAP, namely the Yamashita Teacher Corps, the Pedro Doc Sanchez Program, the ProTech Award, and the ProTech Award. What is eliminated is the Government of Guam Student Loan Program, which is replaced by a program called the Access to Higher Education Financial Assistance Programs. Now, here are some of the changes that I would share with you. On Article 1, and you can follow with me then as we go through the articles. This article, this is the administration part of it. The article remains largely unchanged with the exception of the career priority listing. The new bill, this bill, will allow the University of Guam more latitude into creating a more realistic career priority listing and one that's only renewed every 3 years and not annually like in current law. Article 2, Government of Guam student loans will be eliminated. Currently, this program gives eligible students $6,000 a year to study at the University of Guam any major that is in the career priority list. If a particular major is not on the list, the student may go off-island to pursue that major. Off-island recipients and those pursuing online degrees would be entitled to $10,000 annually. The UOG currently awards about 30 to 35 of these awards every year, every academic year, at a cost of about $250,000 a year. This program will be replaced by the new award called the Access to Higher Education Financial Assistance, and I'll tell you that when I go down to the other chapter that addresses that. Article 3, which is merit awards, will remain largely unchanged, with the exception of removing the off-island benefit. Currently, the top-ranked student of each graduating class, if their major is not available at UOG, may take the award to an off-island U.S. school. Under Bill 509, this provision would be eliminated. When this program was first envisioned, it made sense to allow students to take the award off-island. As UOG celebrates its 60th anniversary this year, we find a more capable university, one that is fully accredited and can meet the needs of our local students. Allowing our tax dollars, the limited tax dollars that we have and that we send to the university, will go off-island to off-island institutions, and technically based on the university's status now, so this practice will no longer make sense. Those dollars should be spent at our local university. Article 4. Several changes are made for this program, primarily the changing of the program name to honor Sus U. Torres, a longtime former member of the UOG Board of Regents. Additionally, the program will now allow medical students attending certain foreign medical schools to qualify for the program. The award amounts for medical professionals are also changed, increasing their award from $25,000 to $35,000. All other provisions remain the same. That was Article 4A. So in Article 4, it creates a new program called the Access to Higher Education Financial Assistance Program. This program is where the bulk of awards is anticipated. A high school graduate meeting certain grade residency and financial need requirements will be available for an award between $500 to $3,000. Once a student is qualified through their GPA, residency, and financial need, the university, based on the federal Pell Grant scale, will determine an award for a student ranging from $500 to $3,000. A student who applies for the program prior to receiving the funds will have to agree to pay back the award through service on Guam. UOG has estimated that between 800 to 1,000 students can be awarded under this program. So the question some may ask, well, what happened to the other programs? The Yamashita, the Doc Sanchez, the nursing training program, etc. Well, these programs will remain unchanged and will still be available. Before any of these changes are implemented, the Bill 519 requires that the university create rules and regulations for approval by the Guam Legislature. Those rules and regulations will detail the awarding of all programs under SFAP. No new funding is being sought. The current appropriated levels, and this is the great news, the current appropriated levels to SFAP is sufficient to award students under all programs. Significant administrative cost savings in the teacher corps, which is incorporating the YTC into the ULG Financial Aid Office, eliminated the need for 5 personnel and their operational costs. The sunsetting of the student loan program will also ensure that the programs in this bill are also funded. At the end of the day, what I expect under this bill is increasing awards under SFAP from just about 200 to 225 new awardees per year to almost 800 to 1,000 new awardees, enabling more of our people to afford a college education. So, Madam Speaker, that is a summary, I know, of all the different articles that, I've tried to explain, of course, in a shorter version. So I thank you very much, and I hope my colleagues will support the passage of Bill 509.
Thank you. Thank you very much, Madam Speaker. To speak on the main motion, we'll go ahead and start up with Vice Speaker B.J. Cruz, and then I have Senator Judy Guthertz. Vice Speaker, you're recognized.
Thank you
And
very
then
much,
Eileen
Madam
Yamashita.
Speaker. It's a point of clarification and a point of inquiry at both. I think the point of clarification is that the Jesus Torres Professional Technical Award is Article 3, not 4.
That's on page what?
Page 12. And my point of inquiry is, though I appreciate the fact that the Professional Technical Award is going to be named after one of the greatest lawyers that Guam has produced, unless I'm reading this article incorrectly, we have now excluded JDs as a recipient of Professional Technical. I don't see Juris Doctorate as one of the eligible recipients of the J.U. Torres Professional Technical Award named after a great attorney.
Vice Speaker, I'm going to take a 1-minute recess. Wampat, I do know you have,
Yes, after speaking with legal counsel, I need to ask if the body, to suspend the discussion right now for 509, and it will still stay, in its place until I'm ready to come back. Okay.
no
Thank-
objection.
Thank
With
you.
that, motion carries. Right now, I'll go ahead and revert back to Senator Palacios on Bill 477. There was an inquiry by Vice Speaker Cruz, and I guess you were to answer that. Please proceed. Senator Palacios, if I may, I'm going to go ahead and yield to Vice Speaker Cruz just to go ahead and give us an update from the briefing yesterday. Thank you. Vice Speaker Cruz, please.
Thank you very much, Madam Speaker. Madam Speaker, I spoke to a representative from the court last night for about a half hour, and in deference to the court, I will withdraw my objection. If the good chairman wants to make an amendment, that's fine, but I'm going to withdraw my objection, and we'll see how this works out.
Sinamasi, Vice Speaker Cruz. Senator Palacios, you may proceed.
Thank you, Madam Speaker. Madam Speaker, with that withdrawal of objection, I think we'll go ahead and proceed with the bill as it is. It is my understanding that a certain senator might make an amendment, but I really I don't want to offer it at this time, which is actually to put a date, a certain date, as soon as the satisfaction of judgment is met. However, Madam Speaker, I'd like to comment that should this go as it is, then I completely understand the concern of the last speaker, and I will make sure that even though it will not be incorporated here, that the judiciary have at least an internal mechanism by which to track this, so that the employee from whom the levy is taken, that person would not be burdened with over withholding, if you will. And so right now, even without this, there's really no specific date, but I venture to say that the court has internal policy that as soon as judgment is satisfied in small claims, now that we know that, there's a process that would indicate, will require a filing of the satisfaction of judgment. And the tracking, of course, the employer would like to know when to stop deducting. So maybe the court, because of this concern, and I'm sure that they know they're monitoring this, and they will do something to make sure that the creditor is not, rather the debtor is not burdened any more than it is with just withholding. We don't want to withhold in excess of what is already the judgment.
Okay. Thank you very much, Senator Palacios. I'm going to go ahead and thank you for the answer to the inquiry. I'll go ahead and acknowledge Senator Tom Atta, who would like to speak on the main motion, but also give you an opportunity to close on the bill at a later time. So thank you, Senator
Thank you,
Palacios.
Madam Speaker.
We'll go ahead and entertain Senator Tom Atta right now. You're recognized.
Thank you, Madam Speaker. I just like to proffer a couple of amendments. One on page 2. First of all, I rise in support of the bill. But I would like to make an amendment on page 2, line 4. In this particular part of section 2, it talks about, except in the case of a levy on earnings, the marshal must execute the writ against the property of the judgment debtor by levying on a sufficient amount of property, if there be sufficient, collecting or selling the things in action. And I'm wondering, is that a legal term, selling the things in action, or are we wanting to say here selling the things in an auction?
Okay. Senator Palacios, would you like to answer that? Would that be action or auction?
Thank you, Madam Speaker. That was brought to my attention, and I think, understand that this is current statute, current provision, and I think that's an oversight. I venture to agree with the the last speaker that that should read auction, because it's talking about selling property, and the only method of selling the property per court order is through auction.
Okay, so I do hear that there's a motion in place. Senator Ada, would that be to delete the word action and reinsert the word auction?
You're right, and it should read then on line 4, selling the things in through an auction.
Selling
So,
Selling the
change
things
the word
through-
action to auction.
just changing the word action to auction. On
Correct.
that motion? No objection? Motion carries. Senator Ada, you're still recognized.
Thank you, Madam Speaker. And earlier, the sponsor of the bill indicated that he believes that that there's internal, I guess, mechanisms that the court uses insofar as the person that's owed having to report to the court that the debt has been satisfied. And I think that maybe with a simple amendment on line 6, we'll really just put that to rest, so that it reads on line 6, the judgment creditors or attorney shall file within 30 days a satisfaction of judgment with the court and serve such document. So at least it puts some kind of finality that, okay, you've been paid off, you have 30 days. Now, what happens if he doesn't make that report within 30 days? I'm not sure. But at least it's clear in the law that that person that was owed has this obligation to file that report within 30 days.
So what line is that on, Senator Ada?
That's on line 6. And so on that line, it should read, attorney shall file within 30 days.
Line 6, page 2?
I'm
In
sorry,
page 3?
line 6, page 3.
Can you get that in writing? On that motion, are there any objections? If there are no objections, motion carries. Senator Ada, can you just make sure that that gets written?
Right, as soon as the
Yeah.
clerk is writing it up.
Thank you. Anybody else wishing to speak on the main motion? If not, Senator Palacios, would you like to move it to the voting file? On that motion to move it to the voting file without any objection, motion carries. Bill 525, Senator Respicio, not. We'll go ahead and proceed. Senator Yamashita on Bill 263-31.
Thank you, Madam Speaker. I ask that Bill number 263 -31 as substituted by the Committee on Appropriations, Taxation, Public Debt, Banking, Insurance, Retirement, and Land, and further substituted by the Committee on Appropriations, Taxation, Public Debt, Banking, Insurance, Retirement, and Land be moved to the third reading file,
Would you like to speak on it?
and I would like to speak on it.
Without objections, please proceed.
Thank you very much, Madam Speaker. Madam Speaker, Bill number 263-31, as everyone will recall, was heard on session floor in January. We had crafted the measure in July after hearing from community representatives. Speaker Ben allowed us to have a public hearing in November of 2011, and it made it to session floor on January 18th of 2012. And during that particular session, I certainly learned a lot. I learned how that the deliberation by members really does make a measure more doable, reasonable and more doable. And and only if we're able to come to an understanding of how to move forward on a measure, it will not move forward. And so with that, I did move this measure back to committee, and I did more work on it. We will all recall, I'll just very briefly describe what this talks about. We will all recall how I spoke in January about how Well, we have 159,000 people on our island, perhaps a little bit more to include our military families. We have 109,000 cars registered on our island. We also had our top import are vehicles. So we have a lot of cars on an island that is 30 miles long and about 4 miles wide. We have a mass transit system that is going to get better. But in the meanwhile, most of us depend on our vehicles. We take great pride in our cars and we invest a lot of money. And what community people are saying is while they follow the laws and they take care of their cars, and as they go from place to place, and as they try to park within their yellow lines, they can park within the yellow lines, but then they can't get out of their cars. And so it perhaps can be said that once upon a time, the top choice of cars were compact cars, but today there are many standard cars and there are many trucks. And so this measure really is an attempt to help us take better care of our property by widening the parking slots by a foot. And we had gone through all of this in January, and the concerns were, number one, I had not proffered a grandfathering clause at that time, and after it was reverted to committee and after more conversation with colleagues, with community leaders, with business owners, the substituted bill now has a grandfathering clause in it. And you'll find that in all the sections that says, starting on page 2 and to page 3, all the language that talks about and one parking space for each 125 square feet of customer area and such use for each facility that was built prior to or for which building permit was issued prior to March 31st, 2012. Those clauses are all intended to grandfather. Now, March 31st, I will be proffering an amendment to change to December 30th, simply because we're already at November. But that was the purpose of those amendments to grandfather. Anybody who has already received the permits and has already been following the parking slot criteria is fine. It's here on out that we want to ensure that everybody has, whoever's striping now will provide for an extra foot so that as we get in our car, we can actually get in, and as we're leaving our car, we can actually get out without praying that we don't drop everything and that no one's watching us trying to get in and get out. Now this bill has been supported by the Department of Land Management, Department of Public Works, and the Attorney General. The Attorney General's major concern was to ensure that we had at least a year for effective, to have it in effect a year after passage, if it makes it to passage, and so that is also included in here, that there will be at least 1 year before the measure is in effect, and that Department of Land Management and Department of Public Works will work together. And so I believe I've addressed the concerns. Also, I did meet with the Hotel Restaurant Association President, Mary Torrey, and she assured me that certainly everybody in her association is well aware that this bill is out there, but she had not received any concerns. Nobody has forwarded her complaints, concerns, or otherwise, and she thought that it would be very useful to having customers, clients, feel better about parking and leaving their vehicles in a parking lot. And I also want to say that even without this law, it's clear that some businesses are already giving us a little more space to park and leave our vehicles. I had the honor of attending a ceremony for one of our brand new hotels coming up, and in talking to their engineers and planners, they told me that already their parking slots are going to be 9.5 feet across. And so people are already understanding that kind of need, as well as they assured me that the number of slots for those of us with disabilities is absolutely being adhered to. So, Madam Speaker, I ask for consideration by our colleagues. I think that we've addressed the concerns. There is grandfathering. There is a year before it goes into effect. Everybody stands in, Department of Land Management, Department of Public Works, the Attorney General is in support. Hotel Restaurant Association is in support, and I believe those issues are now addressed. I thank you for the consideration. Thank you.
Sanamasi, Senator Yamashita. Anyone wishing to speak on the main motion of the bill? Senator Atta, you're recognized on the bill.
Thank you, Madam Speaker, and I certainly commend the sponsor of the bill for having taking the bill back and addressing the issue of the facilities that are currently in existence, and making sure that by virtue of this new law, that then they are not put out of compliance. And I guess the grandfather clause actually will take care of that. I do have one question though on page 5 regarding the which is the new section 6. And it talks about that this act shall be effective 1 year from enactment. And I guess that's appropriate to give basically new facilities that are coming online time to go back and make the necessary changes to their plans. But I do have a question about who's going to enforce this. And right now it shows here on line 21 that basically the Department of Land Management will be the one tasked to go out there and make these inspections and evaluate the establishments for compliance. And then the Department of Public Works shall revoke occupancy permits from those establishments or structures who fail to comply. And I'm just thinking that maybe what's going to happen then with this kind of arrangement is land management is going to go out there, they're going to do their inspection, they're going to write up, and they're going to send their findings to Department of Public Works. Public Works then is going to take their inspectors, going to go out there and inspect it also, and then determine at that time whether the findings of their inspection is in fact that the building is not in compliance. And I would just recommend that maybe that the responsibility for inspection and determination of compliance should probably rest with Public Works. And if Public Works, as a result of that inspection, determines that the facility is not in compliance, then, based on their findings, should go ahead and issue ultimately the revocation of the occupancy permit. So my amendment would simply be on page 5, line 21, that it should read, the Department of Public Works will evaluate the establishments for compliance, and shall revoke occupancy permits from those establishments or structures. So that's the amendment that I proffer to change, replace Department of Land Management to Department of Public Works, and unless there's a specific reason why land management should stay in the picture.
On the motion, are there any objections to changing the Department of Land Management to Department of Parks, Public Works? No objections? Motion carries, Senator Ada. One
final concern that I would like to raise, Madam Speaker, on that same section 6 is that it requires, it's really very prescriptive that if the establishment is not in compliance, the Department of Public Works shall revoke occupancy permits. And I'm concerned about the use of the term shall, as opposed to maybe changing that to be more permissive, to say may, such that then the Department of Public Works really needs to work with the facility to try and get them into compliance. And if, you know, if the facility just blows them off and say, oh, you know, I don't have time for that, then they may have to resort to that revocation. But otherwise, I would then make another amendment on line 22 to change the word shall to may.
On that motion, to change the word shall to may, are there any objections? No objections? Motion carries.
Thank you, Madam Speaker.
Anyone else on the main motion? If not, Senator Yamashita, would you like to close?
Thank you very much, Madam Speaker, and I appreciate the amendments proffered by the previous speaker. Just to ensure that we know that on page 3, Madam Speaker, the March 31st dates will all change or be amended to December 30th dates.
December 31st.
Yes.
On that motion, without any objection, motion carries. And to move it down to the voting file, without any objection, motion carries. Next on the agenda, we have Bill 361. Senator Guthers, are you ready?
Thank you, Madam Chair. Bill 361 is a very simple bill. I'd like to move it to the reading file for discussion purposes.
Please proceed, Senator Guthers.
Thank you. This bill is an effort to try to assist with registering eligible voters for the self-determination vote. And it simply allows departments and agencies of the government of Guam to establish registrars within their departments to be able to register government employees and or customers of these departments and agencies who might fulfill the requirements to be eligible to register for this vote. At the same time, the bill encourages nonprofit civic organizations and even private business establishments for becoming registrars at their location so that they can register their employees and their customers that are eligible and meet the criteria for the plebiscite vote. The initiative is intended to really assist the appropriate entities of government responsible for this effort by expanding the potential sites where individuals who qualify may register. So that's the intent of this, Madam Chair. Thank you very much.
On the motion, Senator Tony Ada.
Madam Chair, if I can just take a short recess just to follow up on my questions that I have for the author. Thank you.
Brief recess. Tony Ede.
Thank you, Madam Speaker. I did confer with the author of the bill and that she'll be proffering an amendment. Thank you.
Okay. So, on the motion, is there anybody else who would like to speak? Senator Gutherson to close.
Thank you, Madam Speaker. Also, I want to thank my colleague for making one observation that does require clarification. On page 2, line 20, it says that the Imagalayan Guahan shall issue an executive order to all department agencies and instrumentalities. I think we cannot require the governor to issue an executive order.
Is your mic on? Can I
Yes, it is.
Okay, thank you.
We cannot require the governor to issue an executive order. So we have to revise this and simply say, Imagalayan shall facilitate the intent of this act by coordinating with departments, agencies, and instrumentalities. Imagalayan shall facilitate the intent of this act by coordinating with all departments, agencies, and instrumentalities of the government of Guam.
Okay, so you're going to amend
Line
page
20.
2,
Line 20.
line 20, and it
Yes.
read Imagalayan Guahan shall, and you're going to delete issue
Shall.
the executive order.
Yeah, take that
right?
out.
Take that out and add the words
Shall facilitate.
shall facilitate the intent of
Yes.
this act
Right.
by coordinating with all department agencies and instrumentalities
Right.
and so
Everything
on.
else stays the same.
Okay. So on that amendment, and please make sure it's in writing for the clerks.
Yeah, I think he's writing it down and speak.
On the amendment, Senator Tamada.
Madam Speaker, maybe if the author would yield, I just have a question, not necessarily on the specifics of the language that has been offered, but right now, I guess, as I understand this bill, is to enable each department to designate someone to be a registrar. But it's not clear, is that person that's designated now, can that individual go around to each eligible registrant and kind of start making the pitch for, here's why you got to register, and, you know, just, or that there shall be no campaigning at all that'll be allowed?
Yeah. Madam Chair?
Do you yield to the question?
Yes, I'd be happy to clarify. Yeah, the purpose of the registrar is simply to register eligible participants from their departments or agencies or those that conduct business with the departments or agencies, not to campaign for any political status.
Senator,
But,
did
but
she
it's
answer
not,
your
but it's
question?
not clear in the bill that shall be prohibited. I mean,
Well,
it just,
it's not stated that they're supposed to campaign for political status.
no, I know that. But if the law doesn't, my understanding is that if the law doesn't have a prohibition on it, there's nothing to
Well,
restrict them from doing so. And you may just get an overzealous registrar who may then start doing their own little campaigning and, you know, just...
well, I think that might be a good point. If the speaker would like to offer just a short amendment, we could add it.
I'm not sure where...
Senators, why don't we take a brief recess?
You say the registrar shall not.
Back in session. Senator Guthertz on the amendment that she proffered in page 2, line 20, where it says, Imagalan Guahan shall facilitate the intent of this act by coordinating with all departments, agencies, and instrumentalities of the government, and so on. So, any objections to the amendment? Hearing none, so ordered. The second amendment, Senator Guthertz, on your second amendment, which is the language from the Election Commission office. So, no, I need for you to make that motion and suspend.
Thank you, Madam Speaker. Madam Speaker, attorney is drafting the amendment which will designate the Guam Election Commission to oversee the registrars from the government agencies and also the volunteer registrars from nonprofit organizations and private businesses, and to ensure that they are compliant with the proper protocols. So legal counsel is drafting that amendment. May I request our colleagues to please support that amendment? And I can read this, what we'd like to add, ma'am, as a new section to the bill in keeping with that intent. All employees designated to act as registration clerks shall meet all the qualifications of this chapter, and that's GCA Chapter 3, Section 3105.1, and shall comply with all laws, rules, regulations, and procedures governing the conduct of registration clerks. The Commission shall develop rules and regulations and procedures for the appointment and training of registration clerks.
Okay, so what your intention then here is to instead use the title, not to repeat everything again in
Correct,
this law,
correct.
but to make reference to that particular title, chapter, and
Right,
section
correct.
under the Election
Yes,
Commission. On that amendment, does everyone have a clear understanding of the amendment? Are there any objections? Hearing none, so ordered. So on the motion then to send, what's the number of the bill? Bill 36131 then to a third reading file without any objections, so ordered. Senator Tony Ada, you're recognized on Bill 385-31.
Thank you, Madam Speaker. Madam Speaker, if I can make a motion to move Bill 385-31 as amended by the Committee on Public Safety, Law Enforcement, and Judiciary to the third reading file. Second
Yes,
motion.
you may proceed.
Thank you, Madam Speaker. Madam Speaker, Bill 381-35 takes into account two concerns: the safety of children and vulnerable adults, and the extremely high rate of recidivism of convicted sex offenders. I'd like to thank Chairman Palacios for making this a stronger and better bill. And if enacted, this bill would prohibit the employment of convicted sex offenders from working in facilities that are frequented by children and vulnerable adults. And these are places such as daycares, schools, clinics, hospitals, nursing homes, hospice facilities. And it also prevents these individuals from working in places where they might be required to enter private residences. And these are positions such as repairmen or delivery positions. Just this past year, Madam Speaker, we have seen numerous arrests for repeated sexual predators. And I'm sure that the public will rest knowing better that their clinic or schools will not employ sexual predators, or that sexual predators will not be installing telephones or delivering appliances into their homes. I ask that my colleagues support this measure. Thank you, Madam Speaker.
On the motion, Senator Yamashita and then Senator Palacios.
Thank you very much, Madam Speaker, for giving me the opportunity to speak on Bill number 385-31. Madam Speaker, I stand in full support of this measure and what it intends to do, and I thank the author for proffering it. I do ask that we consider a few amendments and the limitations on employment of convicted sex offenders. So these people have already been convicted of violating violating people sexually. And I ask that we consider that if you are a convicted sex offender, that you shall not have any access to a child care facility, whether or not we know children are present, or to a school or learning institution, whether or not we know children are present. And as you know, we might say that classes are not in session, and we might say that this campus is closed right now, but oftentimes a teacher or a school leader or a staff member will come back to the school and do work, whether it's during the weekend or during night. We always find a way to get our work done. And so we might have kids there with us. And so what I'm asking is just to consider that, convicted sex offenders may not be employed in any child care facility, in a school or learning institution, and then further in a hospital, nursing home, or hospice facility. Because that's also a place where you would have people there. I mean, there's always going to be people in a nursing home or a hospice facility. There are always going to be patients there, I would think, unless I'm not understanding what I'm reading. And so, Madam Speaker, the idea is that wherever there's the opportunity for children to come back, even if officially that school day is shut down, there's always a chance that kids will be back, whether they're there playing in the playground, whether they're there with their parents who are teachers, whether they're there with their grandparents who are the principals. They're there escorting, helping, just being there with their family members. And if these convicted sex offenders are there, it's better to be safer than sorry, and just saying that we don't give them any opportunity to be in the same grounds where the guard may be down, our guard may be down, thinking that nobody is watching. Because even if it's just one child who's on this facility or in a school or learning institution or a nursing home, that's all it takes is one opportunity. So, Madam Speaker, I proffer that we delete while children are present in B and C, and then while patients are present in E. I look forward to the deliberation on those thoughts. Thank you, Madam Speaker.
Okay, let me see if I got it right. So it's for A, B, C, and D?
It's for B and C.
B and C to delete while children are present.
Yes.
Okay.
And then E.
And E while patients are present.
Yes.
Okay, so that will be,
Which essentially means that anybody who's been convicted of a sex offender may not be employed at a child care facility, at a school learning institution, or at a nursing home or hospice facility.
okay. So on the amendment, Senator, yes, Ada.
Thank you, Madam
Tony.
Speaker. If I can just have a
A
brief recess. Yeah.
Okay. Brief recess. Senator Yamashita, you still have the floor.
Thank you very much, Madam Speaker. After speaking with colleagues on the floor and after understanding that perhaps more thought needs to go into what I'm actually raising, and please know that I am supportive of restorative justice and all. I really am an advocate of second chances and third chances and more chances, but I'm also very concerned about safeguarding safety. But in that vein, for now, I'm withdrawing my amendment. Thank you.
On the motion without any objection, so ordered. Is there anyone else who would like to speak on the main motion, which is for Bill 385? There being none, Senator, you will send it down? Okay, so on the motion to send 385-31 to the third reading file without any objection, so ordered. We are going to, let's see. Let me see. Yeah, we're going to, I think we need to go on recess, and we will return at 2 o'clock this afternoon.